My strong opinion is that subnational governments get away with murder when it comes to facing down a federal administrative agency. Here's a classic example.
So they're the stronger players.
Much stronger. Let me give you the classic example.
Pontiac School District versus the federal
the classic example, of course, is the 1975 Highway Appropriations Bill that said states had to have a speed limit of 55 miles per hour. That was a dead letter as soon as it came off the out of the Congressional Printing Office. Every Western state disobeyed that mandate, and the Federal Department of Transportation backed down immediately. Here's the problem with the sanction of pulling a grant. You're the Department of Education. You just heard that the Centerville School District is not obeying the grant conditions for helping low-income kids. So you yank the grant and hurt the low-income kids even more? Bizarrely implausible. The only way those conditions ever really seriously get enforced, given that the federal agency does not want to yank the grant that its clients depend upon, is when private parties bring private causes of action, which have largely been squelched by the Sandoval decision.
Yeah. Why don't we take some questions from the audience? Well, I think they're lined up on both sides. We'll start over here.
Is this microphone working?
Yep.
Yes,
Now it
okay,
is.
thank you. I want to pick up on the point that John Eastman raised with respect to Butler and ask Rick Hills. You spoke about spending for mixed goods. I fail to find any authority in the Constitution for spending on public goods, period. I find authority for spending on various public ends, and it seems to me that what you've taken is the Hamiltonian view rather than the Jefferson-Madison view that John spoke about. And William Drayton addressed that very clearly in 1828 when he said that since Congress could use money to accomplish any end, then in doing so, it could use the general welfare clause and make an end run around the doctrine of enumerated powers. So it seems to me the issue before the Sixth Circuit was not necessarily the no child left behind, but where's the authority to spend on education under the Constitution? But that doesn't get John out of the problem either, because it seems to me that if you've got judicial enforcement, you've got the standing problem to come up with under the spending clause, which of course there is no spending clause, there's a taxing clause.
You want to take, let me take up the standing doctrine first. It's rare that I say this, particularly at a Federal Society event, but I think Justice Scalia is wrong on standing doctrine. And I commend to your attention in the spring 2001 issue of the Chapman Law Review, a wonderful article called Standing and Spending, the Role of Legal and Equitable Principles by Richard Epstein. It's 100 pages of why Scalia is wrong on that. I mean, look, the Article 3 power is for legal and equitable powers of jurisdiction in the courts. And it was always part of the equitable common law tradition that you didn't have to have a particularized harm, that everybody that collectively had the same harm, somebody could still challenge that. And compare it to a shareholder derivative suit. No individual shareholder has any harm when the board of directors or the officers of the corporation violate their charter, their corporate charter, and yet anyone's able to bring a shareholder derivative suit on behalf of all shareholders challenging the violation of the charter. That's essentially what taxpayer standing is. And if we had an adequate taxpayer standing doctrine that could challenge unconstitutional spending, I think it's easily within Article 3's equitable powers, and I think we should have it.
Good. Rick, I think partly it was addressed to you. Do you want to briefly?
Well, just that, there were a bunch of antebellum nut jobs. John Randolph, the Quid Republicans, the sort of old Republicans who took a very narrow reading of the spending clause. They were routine. You can quote a million speeches. John Randolph had some great ones. Madison's position was universally rejected by every major political figure, including the cheapos like Andrew Jackson. Andrew Jackson, who was hardly a big spender on the federal side, in the Maysville Road veto message, explicitly adopts Hamilton's position. And indeed, no federal regime could survive with Madison's position for long, because no federal regime could survive without the category of mixed public goods. And the Constitution provides for spending on the general welfare. That means, I presume, goods that serve general purposes. There are a lot of goods that serve both general purposes and local purposes. If you don't have federal funding for them, you will be a critically, and I believe fatally weakened regime, which is why no one in the antebellum period took the Madisonian position seriously or consistently. For instance, everyone believed the national roads like the Cumberland Road could be funded. Monroe, who was a real tightwad, believed it could be funded, but it could not be defended under any of the provisions there unless you said it could only be used by mail carriages.
On this side.
Hi, my name is Charles from Michigan, and speaking of general welfare and economic crises, I'd like to advance the calendar to 2013 when we have universal health care. And having universal health care, you're hired by the Attorney General of, let's say, a state like Alaska, who wants to take the position that federalism is not dead versus the government that's saying, on an actuarial basis, unlike the 55-mile-an-hour speed limit, if we don't have all 50 states in, this whole thing collapses. How would you defend federalism in front of the 9 judges?
You want to try that? Or?
In terms of under current precedent, I think under current precedent you're going to lose. I concede that. My argument is that that current precedent, much of it is incorrect. So I think if this really is a situation where the reason why you need all 50 states is because otherwise people or businesses will flock to the one state that doesn't have national health care but rather has some sort of private health care, then that to my mind is a great example of why the federal government should not be doing national health care, because this here interstate competition would be showing that actually some more private form of health care is better. And more broadly, this goes to the question of I think in some presentations on federalism, including some today, there tends to be a conflation of things which are in the national interest in some broad amorphous sense and things which therefore the federal government should do. And in my view, many beneficial things which are in the national interest, including, I would argue, healthcare and education, are usually best addressed through interstate diversity, competition, and voting with your feet, rather than by having one-size-fits-all federal programs. The case of education mentioned earlier is a great example. We've had 40 years of ever-increasing federal involvement in education, more and more federal mandates and spending, and the overwhelming evidence of studies is that that has not improved educational outcomes. On the other hand, there is evidence that what does improve educational outcomes is competition, especially through school choice, but also to some extent competition between school districts. I would say the same thing also with healthcare and some other policy areas, that just because something is valuable to the nation as a whole in some broad sense doesn't mean that it should be pursued by the national government, and doesn't mean that it should be used as a justification for ignoring the text of the Constitution, which imposes constraints on the scope of federal power.
Over here on the left.
Jay Schweikert, Harvard Law School. I have a question for Professor Feeley, and this goes to what he was saying about political identity, which he seemed to describe as willingness to fight and die. And it seems like that's probably true for many countries throughout history, but the United States may be different in that we're a nation bound by ideas, and chief among those is individual liberty and constitutionally constrained government. And I think this relates to federalism in the sense that, as O'Connor identified in New York v. United States, political safeguards of federalism aren't enough because it's not about protecting states, it's about protecting individuals, and that we use this system as a structural limitation on the federal government, not to protect states, but to protect individual liberties. And so if we have a conception of political identity that's based in this ideological support for individual liberty, why is it that these procedural or political safeguards of federalism are going to be enough?
Pardon me, a good point. I guess I don't see giving geographical areas, the states, as a particularly useful a way to protect individual liberty. And I think of the history of the expansion of liberties has not come about by protecting states. Indeed, I went to a segregated school in San Antonio, and it ceased being segregated after the federal government ceased to said we'll pull our dependents, military dependents, out of the public school system, and the San Antonio school districts desegregated K through 12 in about 12 months in the fall of 1956, and so it seems to me that's how we've protected individual rights over time has been almost, not always, but has been primarily through the expansion of national values that have been promoted either by the Congress, the President, or the federal judiciary, not by protecting states.
Well, the federal government wasn't too good on desegregation in their own backyard. They needed Bowling versus Sharp about the same time.
But again, it was the federal judges that did that, not the local city council.
Right. Over here.
The panel has discussed some of the institutional safeguards on federalism, whether that be presidential vetoes in early American history, or the possibility of of judicial intervention. I'd like the panel to comment on the U.S. Senate as a protector of federalism. The way I read the Constitution, it was intended to be the advocate to the states because the state legislators would elect the senators until the passage of the 17th Amendment. In my opinion, federalism died when we passed the 17th Amendment. Would these panelists agree or disagree, and do they have any comment on that issue? Thanks very much.